When probate and evictions meet, does the personal representative of the estate, can they evict occupants in possession of property if they're potential heirs at law to the estate? Hi, my name is Rob Wells. I'm the Landlord Warrior on TikTok and YouTube. Please feel free to like, share, and subscribe to our videos. Now, I just had a post I just read from another colleague of mine that was talking about an eviction case going on. The question or issues were this: client or the personal representative of the estate, who is the legal spokesperson for that estate, initiated an eviction or unlawful detainer action against several siblings that occupy the decedent's residence. Okay. It sounded like it said in the post that the person doing the eviction is the administrator, meaning there's a probate estate in the Superior Court opened up, and there appears to be no will. Okay, so that would mean, in my mind, an administrator in a probate estate is usually a person that's appointed when there is no will. There's no document saying who gets what or so forth. When you die without a will in California, the probate code dictates what happens to a deceased person's property. Okay, and usually your heirs at law get that. Okay, so my understanding of the situation is the administrator starts the eviction. The occupants, who are also heirs at law, claim, hey, you can't evict me because we're heirs at law. We were left this house type deal. Okay. And that's what the eviction court is going to have to decide, whether this involves, has to be dealt with in probate court or in eviction court. Okay. So a couple of questions that I'm going to ask in my mind is, and I know this is, if there is no will, okay, there is no specific devise or gift of this property. Okay. If it is a true intestate estate. Okay, can't think right now. An intestate estate means no will. Okay, so my question would be, how did these occupants get into possession? The siblings get into possession. Okay, what it sounds like to me, and what the typical case is, mom, dad, whoever the decedent is, let the children live with them. Okay, it said in the post there is no charge of rent. That puts it possibly as a tenancy at will. All a tenancy at will is there's no contract to pay rent. Okay, and it's a tenancy that's of an indefinite nature. Okay, so I let you into my house, I let you live here, type deal. I don't charge you rent. You're a tenancy at will. That's usually common with adult children, so forth like that, living with mom and dad. Okay, usually there's no contract to pay rent. That being said, the first thing I'm going to look to is, for a tenancy at will, under Civil Code Section 1934, that tenancy at will is terminated upon notice of death of either the tenant or, in this case, the owner. Okay, and as a matter of law, tenancy at will is terminated once either landlord or owner dies or tenant dies. Okay, and what ends up happening at that point is the administrator or the legal representative of the estate is going to have to initiate unlawful detainer proceedings. Okay. Good news, it sounds like in this case, is the administrator has been appointed by the court already. She has letters of administration. So she has the legal grounds to initiate an eviction or unlawful detainer. So that hurdle has been cross. I guess now the question would be for the probate court is, okay, can this administrator terminate the tenancy with a eviction versus going to probate court? I think if it is a true tenancy at will and the administrator has been appointed, and because there is no will leaving this specific piece of property to the tenants, I think the administrator is in their legal authority to use an unlawful detainer action. Because again, once a party dies in a tenancy at will, the tenancy's over. Okay. Now, the facts might change a little bit if the administrator accepted rent from the heirs, okay, that are in possession. That would actually create a new tenancy in the civil code, and that would be a month-to-month tenancy. Okay, and at that point, depending on how long the occupants or the heirs have lived there and so forth. Legal notice might need to be given to terminate that tenancy. But under this post, under these facts, assuming no rent's been paid, I think the administrators in their lawful rights to terminate the tenancy, go through an unlawful detainer. Okay. What if the eviction court says, you know what, this is too hot to handle, okay? We don't want it, there's too many things going on, okay? This administrator in the probate proceedings could initiate what's known as a probate code 850 petition, okay? And that's probate code 850 is a very broad statute that allows a probate court to determine possession, title, who gets what, from a decedent's estate. Okay, they're very common. The common Hagstead petitions, for example, use probate code 850. It's when you forget to put something in your trust and it was intended to be in your trust, but something happened. Okay, that same 850 petition could determine who the heirs at law are and who's entitled to what. Okay, and in that 850 petition, the administrator could make a cause of action for unlawful detainer as well, and they would be evicted through the probate process. And another thing about an heir at law is, especially in a probate administration, is if they are heirs at law and they're wrongfully excluding the administrator and other heirs, from administering the estate and so forth, the administrator possibly could ask the probate court to surcharge these heirs for wrongfully withholding possession of the property and to charge them a fair market rent for the unlawful detention of the premises. So if they had to go through that, I don't think they would. The probate court has more powers to actually compensate the estate and the heirs by, charging the tenants rent and also granting them relief. So it might be a longer process to go through a probate 850 petition or something of similar nature in the probate courts, but the probate court has more power than the eviction court to do, to handle heirs and who gets what and so forth. So an eviction court will give you just possession, maybe what we call fair market or holdover damages from the time the notice expired and so forth. But the probate court can go one step further and, tell heirs that they're going to have to leave and, adjust what the heirs might get in a final petition for distribution. So those are my thoughts. This video went super long. We don't usually cover these things, but I thought it was a very interesting topic, particularly with probate administration, because we do run into these issues as a landlord attorney. I run into these situations a lot, and I used to practice probates and trusts in the States, so it can kind of get complex here when the rules, when these issues merge together. So owners of property, personal representatives, trustees, if you got a probate, situation, or you got heirs, in property, and you're not sure if you can use an unlawful detainer, or, you're going to have to go through the probate process, and you're in the Northern California area, feel free to reach out. We might be able to help out and get some guidance. It's going to be very factually specific, and it will turn on what has happened after the decedent has died, or the person that has property, they died, and so forth. So, and facts, localized rent control and so forth can change the outcome. So, you're going to want to talk with, counsel that does evictions on a daily basis here. So if you need that help, reach out, okay? Put your comments, questions down below. Answer them to the best of my ability. Until next time, folks, I'll talk to you then. Thanks.